Well, good morning, folks. Happy Wednesday morning. What are we at the fifth day of June? Can you believe June is here? Now we want things to slow down to enjoy the next couple of warmer months, hopefully warmer and less rainy months. My name is Jim Reedy, and I'm from Sheehan Finney. I'm an attorney with Sheehan Finney's Labor Employment Group. We are the host of the New Hampshire Tech Alliance HR Exchange, and it's my honor and joy to be here this morning with you. This is our last program of the program year. We'll start again in September, but we started last September, and we've had an incredible lineup this year. Everything talking about from leave time to non-competes to National Labor Relations Board issues to financial wellness to mental health wellness to remote workers and so on and so on. It's been a busy year. And I know it's been a busy year for you as well. Last month, we had a pause because we have our annual Labor and Employment Law Seminar. That was our 36th annual. And that was an incredible day. And again, an incredible lineup of presenters and topics and great audience and so on. So many of you perhaps were there. But this program we set aside every year in June to do sort of a recap of where we've been this year and perhaps where the area of workforce or workplace law and regulation is going. So it's a employment law year in review so far because we're in June and there's another half of the year to come for sure. And so as we get started, a reminder that this program is recorded. We have the PowerPoint is also available afterwards. All attendees, just by registering and attending, you get HR credits. Those are available on the last slide. Liz Tezik from our marketing group will be sending that information to you afterwards. Any questions you might have, you can put in the Q&A. I'll be happy to answer them to the extent I can. And let's get started. So, like I said, this is our employment law year in review. Where are we so far? And it's been a busy year. Finally, it is warmer. Well, at least it has been the last couple of days, and there are other signs of the season besides the more daylight, warmer temperatures. You've got the June signals the end of the Supreme Court's term, and there are a few decisions that we're expecting. Leave the political stuff aside, but workplace issues, there are a few cases that are still on the docket for the Supreme Court to be looking at. We're going to talk about some of the decisions from the last year that carried over the implications for the workplace. The U.S. Department of Labor was busy this year. They issued a proposed and then final rule on independent contractors. It's a 6-point test that we'll talk about in a little bit. But it's an economic realities test, and it goes back to the pre-Trump era of a heightened test, effectively, for independent contractors. And why does that matter to you? Well, because if you've got independent contractors, you couldn't fill a position or you have a particular need, you have to be certain under federal and state law. And remember, there are many tests. There's one under the IRS. There's one for workers' comp. There's one for wage and hour. There's one for discrimination. And there's also one for just overall for our friends at the U.S. Department of Labor. If you do not meet the test and meet it convincingly, then you are presumed to be an employee. And what does that mean if it's misclassified? Well, that could be that, unpaid wages, unpaid overtime, no health insurance benefits, unemployment is an issue, workers' comp is an issue, and so on and so on. So, best to pay attention to that. The other thing to pay attention to, of course, is the proposed and now final rule on overtime exemptions. And that was a long time coming. And the last time that this was proposed, which I think was, just a few years ago at the 11th hour, there was a court case that blocked it. Breaking news from 2 days ago is that a court case filed in that same jurisdiction in Texas that is attempting to block the overtime changes, the exemption changes, which we're really talking about there is the changes to salary, the salary threshold going from 684 to 844 as of July 1, and then as of January 1, going up to over $1,000 per week employee. That's the first part of the test. The second part of the test is the duties tests by exemption category. That hasn't changed. But again, there's a looming court case there. So while you are preparing, if your salaries are below the July mark, you're looking to increase those by July. And then also projecting forward to January, know that there's the possibility, I don't know how strong that is, that there may be an 11th hour block to that. The National Labor Relations Board has some rulings on severance and settlement agreements with regard to non-disparagement and other provisions. Liz Bailey covered that in one of our talks here with the High Tech Council, but also at our employment law seminar just last month. And the FTC, we know that for those of you who have non-competition agreements or clauses in agreements, the FTC issued its final rule, which could be effective in late August or early September, but there are legal challenges to that as well from the U.S. Chamber of Commerce and other sites as to whether or not that goes into effect. But if it does go into effect, employers with those types of agreement have to give written notices to those covered employees that part of either the entire agreement or that part of the agreements is withdrawn. Hot topic for sure because of the definition of a non-competition agreement. It may include, and this is subject to legal challenges, may include non-solicitation agreements as well. So another thing to watch for in the coming weeks and months. And of course, another sign of the season is thankfully the Celtics are back at the NBA Finals. A breath of fresh air given the end of the Bruins season and the sort of lackluster training camp for the Patriots and the middle of the pack Red Sox. But oh well, hope springs eternal. So sea levels rising perhaps, but we're also seeing rising levels of workplace claims. And this could be an aftermath of COVID. Because things certainly were turned upside down during COVID in isolation, layoffs, and the like. But we're seeing, first of all, EEOC has updated its enforcement statistics, and it's focused on a number of things. It's focused on migrant workers. It's focused on LGBTQ plus. It's focused on maternity leave claims. It's also focused on religious discrimination, and that certainly is an outgrowth of COVID and some of the issues that came up with vaccine mandates. So typically, and where we are now in our economy is, and I'm not saying anything that you folks don't already know, is that we've got low unemployment nationally and locally. And typically when you have low unemployment, there's lower discrimination claims. They don't go away, but typically they're lower. Why? Because the victims of discrimination vote with their feet. They go to another workplace where instead of suffering hostile work environment or other issues, they move on. We haven't seen that. Even though we've got low unemployment, we're seeing steady numbers of discrimination. In fact, it's increased in certain areas. And that could be a COVID carryover, as we talked about before. Vaccine mandates, pushback to remote work, and so on. But we're seeing an increase. Number one continues to be retaliation. Number two is typically race claims, closely followed by, depending upon the area you're talking about, the geographic area you're talking about, gender-related claims, and so on. But there are more and more pushback claims related to remote work. You know, at the outset of the COVID pandemic, just before COVID, the number of workers in the U.S. that worked remotely was about 6% of the U.S. workforce. At the height of COVID, about 65%. We're still hovering around 35%. And more employers, there have been a number of articles in the last 6 months saying, look, we've got this expensive real estate, come back to the office. And there are pushback claims. Now, some of those pushback claims are in the form of disability claims. I can't come back because of, and it's not because I'm afraid of COVID, although COVID is certainly still around. It's now I've got a bad back, or I'm resistant to the environment. It could be an environment that causes whether it's stress or allergy type of reactions, or there are other claims that I need to work remotely, at least on a hybrid basis and perhaps fully. So we're seeing more of those. We're also seeing more whistleblower and related wage claims, meaning, okay, I put up with it during a crisis, but I'm not putting up with it anymore. And I want alert the federal or state governments or the court systems to what I believe are violations of law, or I believe I've been entitled to unpaid wages or underpaid wages during the last 3 years. In some states, like we were dealing with a case recently in New York, the statute of limitations is 6 years, looking back 6 years. Typically, under federal and most state laws, it's around 3 years. But you can see that we're seeing more and more of those claims. So the EEOC, in addition to producing their information with regard to the charges that they've seen, they're updating their strategic plan, and I mentioned that. And it's a 4-year plan, but it continues to evolve based upon what the agency believes are priorities in the U.S. EEOC's final rule with regard to pregnancy, the Pregnant Workers Fairness Act is out, and we'll talk about that in a few minutes. But basically, it's that is increased effectively focus on pregnancy discrimination in the workplace. We know that back in at the time of the Affordable Care Act, the FLSA was amended for purposes of providing a space for nursing mothers in the workplace. That has been updated again by the PUMP Act, but the Pregnant Workers Fairness Act basically says a number of things, including you can't force a pregnant worker to go out on leave before she and her doctor say that she should go on leave. With regard to remote work, it may be an accommodation. Hybrid work may be an accommodation. Longer work breaks, perhaps, and so on. And the other thing to mention in that regard is that the scrutiny as to whether or not the requested accommodation is something that's truly necessary is different than the FMLA or the ADA. Basically, the new guidance in the final rule says, unless you have good reason to believe that the employee is not being truthful, that you really shouldn't be asking these questions, that you have to take it at face value. And that's a departure from other bodies of law. The ADA and individuals with visual disabilities is updated guidance in that regard, and then also updated guidance with regard to religious accommodations, whether or not it is dress code or accommodations for observance of religious activities. There's updated guidance also on harassment policies and training. Basically, what the EEOC is saying is harassment, and especially in the area of gender discrimination, continues to be one of the top claims, yet employers, especially since #MeToo, have been more conscious and aware of and attending to training. Yet they're saying that training is largely ineffective, or because the claims continue. So that's where we are in that regard. I recommend that guidance, because if you haven't done training recently, look at that, because they've got some good suggestions on how to improve and make your training more effective. Wage and hour issues. The U.S. Department of Labor went back to the future, like I said, with regard to pre-Trump era independent contractor rules, and they also issued a joint employer rule. Joint employers basically are two entities acting in concert, acting together. And if one is deemed to be liable on something, perhaps both could be deemed to be liable. That's in the area of wage and hour, and that's one you have to be careful of when you enter into formal or informal, but sort of got the indicia of some sort of joint enterprise that you may be joined together for purposes of liability. Agreements are good for purposes of saying you have to indemnify us, but it is not a complete protection in that regard. There's a new FMLA poster out. To the extent you want to add more to your break room and your and to the areas in which you have workplace postings, it's available on the U.S. Department of Labor website that just came out in April. There's new guidance on telework. And why do we care about telework from the U.S. Department of Labor? Because, again, more and more employers are allowing people to work remotely. So what is the wage and hour issue that comes up with that? Timekeeping. Timekeeping is any work for the benefit of the employer should likely be deemed to be compensable time, whether or not you've been required to work, or that the term in wage and hour is permitted or suffered to work on behalf of an employer. So you have to look at if it is within the person's primary duties and related duties to their work, and if it benefits the employer. So reminding your teleworking employees that they need to, for those that are non-exempt, meaning not salaried exempt, but the other employees, hourly and salaried, who are non-exempt, to record their time as it is compensable time. Why do we care about salaried non-exempt? Because salaried non-exempts means they're not exempt from overtime. They're eligible for overtime. So even though they're paid on a salary basis, you have to record their time as well, because if they cross over that 40-hour threshold, they're eligible for overtime. My recommendation, the recommendation for most employment lawyers, is if you've got someone who's not exempt, make them hourly, because salary is a guaranteed. It's a fixed, a predetermined amount for a fixed period of time, without regard to quality or quantity of work, with certain noted exceptions. So what you want to be careful of in that regard is make certain their time is recorded. So that's why hourly for the non-exempts is the way to go. But again, if they're teleworking, they're out of sight, they're not out of mind, you have to record their time. And again, they can look back and say, you didn't pay me, and say, well, I didn't get a record of that. It's the employer's obligation to have a record of all hours worked. Who keeps the record? The employee does. So whether they use your payroll system, your HRA system, or they write it on the back of an envelope, you've got to remind, and meaning your managers, supervisors have to remind the employees who are teleworking, full-time or part-time, to record their time from the beginning of the workday to the end of the workday when they've done work for the benefit of the employer, and for any bona fide breaks. And what are we talking about there? A break greater than 20 minutes in duration. Reminder. And again, the U.S. Department of Labor issued their FLSA exemption on overtime rule, and that is to be effective July 1, unless it's blocked by a court case. We are finalizing our checklists on this, our updated checklists on this. If you're interested, shoot me an email and we can send out our checklist. We've got, I think, 9 different checklists for those overtime exemptions. The ones that are most common: executive, professional, administrative, but the ones that are, we also have highly compensated employee and others as well. So if you're interested, just shoot me an email and we'll send that off to you. And the 2-hour minimum, why are we caring about that? That's the New Hampshire Department of Labor has taken an unusual position on this issue. And that is that traditionally, under New Hampshire law, if an employer requests an employee to report to work, and that the anticipation is there in that regard, is the expectation rather, is the person drives from their home to their workplace, and if they're told and notified that there is no work once there, or if the employer attempts to notify them and is unsuccessful and the person still shows up, that they are to pay the employee 2 hours pay, or put that person to work and pay them for the time spent working. Why 2 hours? Because the anticipation is, given the size of our state, if you look at the historical record in this regard with regard to the legislative history, that it was anticipating that the person's commute would be to the office no more than an hour, from the office back to home no more than an hour. So compensating the person for that, when that person had an expectation of working certainly more than 2 hours. The Department of Labor has taken this position during COVID, and now it's post-COVID, they're taking the position that if for a remote worker, if he or she has the expectation of working more than 2 hours, and that person logs on, at a minimum, they're paid at least 2 hours. Now, we're having discussions with the Department of Labor, but that is their position. And the question is, obviously, first of all, was that at the request of the employer? Did the employer ask the person to commence work that day and come into work? That's one issue historically. But the other is, but what does it mean when the person, say, works in the office, but then goes home and logs on? Is that person entitled to 2 hours minimum, or is it whatever the time hours, say, checking an email or sending a text? Could that be as little as 7 minutes, the nearest quarter hour rule, or does it have to be 2? We would certainly argue that if it's compensable time, it would be for the actual time worked. In the case of, again, the person working in the office for the whatever the standard workday is, and then before work or afterwards logging on for a particular purpose, or using responding to a phone call and so on, or doing some paperwork, whatever it is. But it should just simply be based upon the actual time worked. Again, rounding to the nearest quarter hour. Labor, I think, has taken a position where that's not necessarily the case, and we're seeking clarification from them. If we don't get sufficient clarification, and I don't mean just she and Finney or me, I mean the management side of the employment bar, then we're talking about a potential legislative change as well. So stay tuned on that. Here are some statistics from the Department of Labor in fiscal 23, resulted in civil penalties of about $500,000 and 1.3 million in wage adjustments. Wage adjustments, again, are where they order the employer to pay wages back to current and former employees based upon cited violations. And with regard to civil penalties, it is the civil penalty assessed by the Department of Labor, again, where they cite a violation, and it could be anywhere from $100 per employee per day per violation, upwards over $1,000. In fact, it's as much as $2,500 for the egregious violations. Last year, there were over 1,000 separate wage claims filed with the Department of Labor. You can either file with the Department of Labor as a person seeking a wage claim, or you can go to Superior Court. So that's a significant number for sure, and that is those are hearings held at the Department of Labor or in court. And again, the statute of limitations says the claim can go back as much as 3 years. Updated youth employment hours restrictions. It's a little bit more liberal for employers for when youth are in school or on break. Worth checking that. The most important thing on youth employment, though, is making sure your managers and supervisors, and now that we're coming into the summer season when we've got younger people working on school break, that the hours of work, the days of work, the type of work, based upon the age of the worker, are strictly adhered to. And so, one of the things that comes up is color-coded name tags and things along those lines that would be helpful for purposes of saying, okay, so-and-so, you must stop work and must stop work now. And actually, a suggestion that we typically have is 15 minutes before the limit, you should basically be saying, wrap up your time now. So there's no, because even just a minute over could be a violation under state law. Our minimum wage, well, as Dave Juvet mentioned at our employment law seminar last month, said New Hampshire really doesn't have a minimum wage. Well, we do. We observe the federal minimum wage, and that's under RSA 279.27. And there have been proposals to increase our minimum wage, just like there have been proposals in Congress to increase the minimum wage, but it's still stuck at $7.25. Other states, of course, are as high as $15 an hour. So if you've got operations in other states, you must look to those. And what if it's 15 in another state, but the feds are still at $7.25? It's $15. Whatever the higher wage rate is the one that would apply to those employees in that state. Tip pooling and tip sharing charges for those in the hospitality space. You understand that there was a change last year in the statute. Tip pooling is among similarly situated employees. Tip sharing is between the tipped employee and non-tipped employees. There are specific rules in New Hampshire. If this is a stumbling point for you, you can reach out to us. I'm happy to discuss those issues and the policies you have to have, and the procedures you must follow. Remote work timekeeping, we just talked about that, and reporting time confusion. Basically, if you've got employees coming in that have to put on special equipment or uniforms and the like, the question is if that's a part of their primary duty and responsibility, the clock starts then. But if they're going through a security checkpoint, like we saw in the Amazon case of a year or so ago, the question is whether or not that's a part of their primary responsibility and it's not compensable time. And again, go back to remote work. In remote work, it is the obligation for the employer to have an accurate record of all hours worked in every day. It's the employee who keeps the record, reminding your employees and in auditing those records to make certain that that is done properly. And if there are any changes to that, of course, then those changes have to be in New Hampshire, have to be initialed by the employee. Electronic initialing, sure, possible if it truly is the employee doing it, not just simply an acknowledgement somehow that there's an email received. Liz Bailey talked about the National Labor Relations Board and the pendulum swing, and how typically there's a swing between Republican and Democrat in the White House. We're seeing that in the last year or so, more and more employee-friendly rules in that regard. So that's something to watch out for with regard to your handbook policies, your issues with regard to non-disparagement provisions. Largely that's it, confidentiality, non-disparagement, but any questions in that regard, if you're looking at settlement or separation agreements, working with your legal counsel on that, but also with regard to your handbook policies, being careful too. The FTC, as we mentioned just a little bit ago, went nuclear and proposed a ban a year ago, and it was subject to a lot of criticism, but in spite of the criticism that the FTC came out and said, no, we want this to go into effect, and they outlined what that meant with regard to existing agreements and any new agreements going forward that would keep someone from working in their chosen profession. And so we've written a client alert on that. Dave McGrath and Jen Meckel wrote a client alert on that, and that's something that you can find on our website. Watch this one because, like I said, there are real legal challenges to that. But to the extent those legal challenges are not successful as of late August, early September, you'll have to notify your employees, and it's in the millions of employees that could be subjected to. I believe that the statistic I saw was 30 million Americans would have some form of a non-compete or a non-competition-like agreement. And again, it's broadly defined by the FTC, which again is subject to legal challenges. So that's something to watch, and we'll be issuing more updates as we get closer to that deadline. EEOC issued guidance on AI. Brian Bouchard mentioned that at our May seminar, and Brian's spoken extensively on this topic. And I recommend you follow up with him to the extent that you're dealing with AI in the workplace. There, it certainly is a real benefit and tool, but there are traps as well. And what EEOC is talking about here is that there is a potential issue where you're using AI to screen out candidates at the application stage, and EEOC is saying no, you can't do that because it might potentially screen out people on the basis of age, disability, religion, gender, et cetera, et cetera. So you want to keep the human touch in that and be careful about not using AI for purposes of screening employees. And there certainly will be more likely to come. I was just listening this morning on some of the developments with regard to Meta and AI and automatic or default screen capturing and the privacy issues associated with that with regard to your internet searches. I mentioned earlier the Pregnant Workers Fairness Act. So again, it was effective as a law in June of 23. The final rule is now effective, meaning you can't force someone out on leave, a pregnant woman out on leave. It expands the list of possible accommodations, and it limits the inquiries. So what does that get to? That gets to if a person says, I need remote work and my doctor says I do, can you send that person for a fitness for duty exam and so on, or ask for additional follow-up medical? The EEOC says no, take it at face value. Now, could you question whether someone is indeed pregnant? Perhaps, but I would say proceed with extreme caution in that regard. But we'll see more and more claims. We've already seen more claims on a national level with regard to Pregnant Workers Fairness Act. I mean, the public policy behind this is pretty straightforward, which is there is greater protection for the pregnant female in the workplace with regard to possible accommodations, lifting types of work, places of work, hours of work, and so on. But I think we can all agree that there is a strong public policy in support of that, and I think we can all agree that that's a good thing. Pump Act for nursing mothers, again, that increased or expanded the ACA and the FLSA nursing breaks. Remember those, when you go back to the days of the adoption of the ACA in 2009, that, it amended the FLSA for purposes of nursing mothers, but that was for hourly non-exempt employees. The changes here effective in April of last year extended the Pump Act to salaried and exempt employees. Pretty straightforward. And I can't think of an employer that said, well, you're salaried and exempt, you don't get to express in the workplace. I'm sure it was available to all employers, all employees. But there is a New Hampshire twist to this, which is a new law effective July 1, 2025, which is a bit more complicated with regard to it is for 1 year after the birth of a child. It's for employers with 6 or more employees. And like I said, it's effective July 1, unless there's a hardship that applies, and it would be July 1 of 25. And is a private right of action potentially, and I think that's July 1 of 26. It gets to space and travel issues in the workplace, and it gets to reasonable accommodation, reasonable break. The most important thing to mention in that regard, and I think Andrea Chatfield mentioned that at our recent seminar, is that it's enforced. This claim would be enforced by the New Hampshire Department of Labor. It is not a discrimination claim under the New Hampshire Commission for Human Rights. Strangely, this would be under the enforcement of the Department of Labor. That's an added twist. Paid family leave is now a reality in many states, including New Hampshire, although New Hampshire's got sort of the paid family leave light. It was signed into law in June of 21. MetLife is, as you may know, is the designated insurance provider. It provides two types of plans, 6 to 12 weeks of plans available. The employees covered under the employer plan or an individual coverage. So if it is an employer plan, it meets the requirements of the employer plan. And if it's an individual, the individual can elect through MetLife. The employer makes payroll deductions for that. There are about 210 private employers who have enrolled. I think that's as of April of this year, and 9,000 employees. So I think a greater number of individuals have enrolled than before, but we're still, as of April, only 644 individuals have enrolled outside of their, meaning they're not under an employer plan, they're just simply on their own. So we haven't seen a robust individual or even employer enrollment in paid family leave here yet. And there have been a couple of alternatives proposed in the legislature. That one bears watching because other states, California, even Massachusetts, have more robust and mandatory paid family leave programs. That's likely on the horizon for New Hampshire as well, because it's a recruitment and retention tool for your workforce. Has the country finally gone to pot? Now, 43 states have legalized marijuana in one form or another. Did you know that cannabis use skyrocketed during COVID? That could be because of isolation. That could also be someone's self-medicating, or it just would be lots of free time. Last year, this is interesting, retail sales of pot now exceeded chocolate in the US last year. Who would have guessed? And for those smart entrepreneurs out there, it's going to be combining chocolate with cannabis, and it's actually already been done. So will the federal government change its position with regard to cannabis? They have already proposed that. The Department of Justice has already talked about changing from, it was as of last week, revising the schedule for cannabis from a Schedule 1 narcotic, which would be like heroin, and going to Schedule 3 narcotic, which would be steroids and ketamine. So watch for that one, and because that would mean a significant change by the feds, and that also has an impact upon the ADA, which you cannot have an illegal substance, a illegal drug, as a reasonable accommodation. Is cannabis going to be legal in New Hampshire and perhaps going through the New Hampshire State Liquor Store? Entirely possible. That is one that's hung up in the state Senate right now. That it was passed through the House, and we'll see what the governor's position is. But the governor's position seems to have changed on that, thinking that we can regulate it and sell it through like we do the state liquor stores. So stay tuned on that one too, because that will certainly impact the workplace. Now, many employers are not testing for cannabis anymore, but that could change. But even if it doesn't change, if you're not testing, you could still have a policy where you don't allow employees to come to possess it in the workplace or come to work under the influence of cannabis. And when you thought, boy, that's challenging, how about this? Colorado and Oregon have voted to legalize therapeutic mushrooms, or psilocybin. And again, that's highly regulated in a therapeutic setting, a licensed therapeutic setting. But remember, Colorado and Oregon were among the first two states to legalize marijuana. And then once that was done, many states then followed. So, and you think, well, that wouldn't happen here. Well, there actually was a bill in our legislature this year that didn't go anywhere, which was for the legalization of mushrooms or psilocybin. So certainly that one bears watching as well. Supreme Court, I mentioned, we're in the last month of its term. Typically, that's when a lot of the remaining decisions certainly are made. In the last year, the court dismantled affirmative action in college admissions process that had a sort of a light impact upon those employers that are covered by affirmative action in their hiring practices, typically federal contractors. It wasn't specifically on that point, but The question was whether or not it was necessary. The court did fortify its standards with regard to religious accommodation, and it basically issued rules with regard to sincerely held religious beliefs. And then with regard to the more recently, there was a decision that came out this spring saying that a forced transfer as a possible forced transfer of an employee from one position to another could be a form of discrimination. Facts and circumstances, fact dependent. So more coming. Watch for that in the next few weeks. Some regulatory and legislative developments beyond some of the ones I talked about. Again, the Department of Labor is not only wage and hour, but it also is workplace safety, and it issued some regulations said who could be accompany OSHA inspectors in workplace audits. That basically is a representative of the company can follow the OSHA inspector around. Not really anything earth-shattering in that regard. EEOC was delayed, of course, during COVID, and the EEO-1 was delayed. EEO-2 was sidelined for a while. EEO-1 back on track, and now we're seeing the EEOC stepping up its enforcement efforts for those that did not complete their EEO-1 on time. Those covered employers with more than 100 employees. There is a movement in Congress, believe it or not, for a workplace bill, but very few things actually come out of Congress with regard to workplace bills because of the thin margins between Republican and Democrat and between the House and the Senate. But there is one called the Second Chance Hiring Bill. And basically what that is applicants with criminal history, if they're given a second chance. Remember that applicants and employees with criminal history are not in a protected class. But this actually might create the beginning of a protected class for certain individuals with criminal history. It's an opportunity to get those, again, off the dole, to reduce recidivism and get people working again after they've had a criminal history of some sort. But be careful in that regard. You want to follow the EEOC guidance generally with regard to focusing more on convictions than arrests. However, you can still consider arrests under certain circumstances. And the other thing is when you've got a criminal record through a consumer reporting agency, and that is the basis or in part the basis for an employment decision, you follow the Fair Credit Reporting Act for purposes of notification of the employee for issues related to pre-adverse and then adverse action if it is arising out of that criminal record. And the White House launched a cyber workforce initiative. As you know, as of yesterday, the White House also announced new border controls with regard to, through an executive action. Both could have an impact upon the workplace, but the cyber workforce is one looking at the issues related to cybercrime and so on, and things that can impact the workplace. I mean, more and more we're dealing with data breach and ransomware and so on. So the White House is certainly taking a step in that regard too, recognizing the realities of real threats to the American workforce and economy. Workplace bills in Congress, again, the PRO Act is would liberalize issues with regard to union activity. The Healthy Families Act is with regard to sick leave. The PUMP Act, it was a technical correction act, which extended to salaried and exempt employees. There are others with regard to boosting our technical education and apprenticeship programs. And the one I want to mention at the bottom there is a bill, and I think it was Senator Bernie Sanders was proposing a 32-hour work week where the employee would still be paid the same amount. I think, in fact, a part of his testimony was the American workforce is exhausted, and that may be true. That's a generalization, certainly, but the employees would still be paid the same as they're paid currently at a 40-hour work week or a 37-hour work week, but they'd only have to work 32 hours. That obviously did not pass, but that is a precursor to what you might see in other states. You know, there's in Massachusetts, there is a trial policy with regard to a tax benefit to employers who have employees that just work a 4-day work week. And it was actually proposed in New Hampshire as well. Neither has gone anywhere, but that could be, again, something we're starting to see. You see a few trial balloons before something gets adopted. So that's something that bears watching as well. In New Hampshire, we are closing in on the end of the legislative term in crossover, which was in April, which goes from House to Senate or Senate to the House. There are a lot of workplace bills that were proposed in the last year that starts in the fall with LSRs, and then they become formalized. Dave Gervais spoke at our employment law seminar on this topic and also at the recent BIA meetings. There are many things proposed. Few of them made it beyond the proposal, either on the House or the Senate. They ended up either being killed or go to study committee or deemed inexpedient to legislate. But medical marijuana is an accommodation, increase the state minimum wage, legalization of recreational pot, study committee on student loan forgiveness at a state level, payment for accrued but unused vacation time, all have not passed, at least at this point. The two that are looming, though, is hairstyle discrimination claims, which would be, dreadlocks or head covers and the like. Again, hairstyle discrimination is something I know a great deal about, but that is something that sort of came out of nowhere. But it looks like that could certainly become law in New Hampshire. Again, the interesting thing in that regard, just like the Pump Act, the State Pump Act, is that would be a discrimination claim administered by or claims filed with the New Hampshire Department of Labor. Not the New Hampshire Commission for Human Rights, and they're not, the Department of Labor is not equipped to handle discrimination claims in that regard. So that's curious. The other one that's curious is the employee firearms in locked vehicles, protection for employees that can have a firearm in their locked vehicle at the workplace. And that is contrary to most employer policies. In fact, I can't think of an employer that permits it in their workplace. But you can't ask employees about it. You can't search the employee's vehicle. And you can't prohibit it on the premises. That could become law, and that would be a radical departure. And you think about, obviously, the obvious workplace safety issues, workplace violence, and so on. Perhaps the genesis of that was with regard to Second Amendment rights or even hunting issues. But do you want to have employees with firearms on premises, even though it's in a locked vehicle? So that one is one that we're going to continue to monitor, but that looks like that may become law. Some that didn't make it, lots of other cannabis bills. Mushrooms were proposed, therapeutic mushrooms, psilocybin. Some issues with regard to remote work arrangements, criminal record checks for teachers, prohibiting certain types of AI. Again, increase the state minimum wage. And yes, an alternative to being paid by check or cash, being paid in gold and silver. I think that was proposed by a pirate, but that didn't get anywhere. And yes, we want to watch our southern border. We don't want to become Massachusetts. We like the New Hampshire advantage, taxes and otherwise, but also certainly our legislative process is different. Our legal structure is different. But I mentioned the 4-day work week, and that's something we want to avoid. We also don't want to have the same non-compete garden leave laws that are in Massachusetts and their paid leave laws. We want to have our own New Hampshire versions of these things. What's on the horizon? There could be a block to the overtime rule. That's one to bear watching. Like I said, that was just 2 days ago that a claim was filed in Texas, the same court that blocked it last time. There could be changes under the federal drug laws with regard to changing cannabis from Schedule 1 to Schedule 3, and to non-competes, certainly with regard to the FTC rule. Indefinite accommodations under the ADA. Well, you don't typically have that, but we're seeing the possibility of that in some courts. Widespread 4-day work week, more and more states are entertaining it, and the rise of the machines with automation and AI. Sure, for sure. And it's only June. So lots more to come. Stay tuned. I want to thank you all for your attention this morning. There is certainly lots more to come. Stay tuned. Thanks for your time. I actually, I'm going to respond to some of the questions I've seen here. I've got a few. And I'll respond directly to the individuals to the extent I can. If not, send me an email, jreedy@sheehan.com. I'm happy to help. I want to thank all of our presenters this year. I want to thank the New Hampshire Tech Alliance. I want to thank Liz Tezik and Kelly Trudell for helping put this program together, for my legal assistant, who many of you know, Sandy Rolfe, for her amazing work in supporting our practice and all these presentations. I want to thank you all for being part of this. Stay tuned. Again, the credits are here. Liz will follow up with you and send you the materials from today. But any questions, you can always contact me. Here's my information. I want to thank you again and wish you the best of luck today and the remainder of the summer season. Let's stay in touch. Thanks so much.